here, and welcome to Constangy TV's Close-Up on Workplace Law, where we zoom in on recent developments of interest to employers, to their attorneys, and to their human resources professionals. I'm your host, Leigh Tyson, and I'm a partner in Constangy's Atlanta office. So, what's in store for employers in 2019? Here to talk to us about it and kind of look into our little crystal ball like he did last year is Tim Newton, one of my partners from the Atlanta office. And Tim is a very experienced litigator who works with discrimination cases and FMLA and pretty much all of it, I think, right, Tim?
Pretty much everything.
Pretty much everything. So he's a good guy to come back again this year and tell us a little bit about what we have in store for 2019. So, yeah. Tim, thank you so much for being here.
It's good to be here again.
All right. So last year, we were very young, very innocent. So remember how young we were?
I didn't need reading glasses.
When we talked last year, some of the things that we thought would probably be coming up this year, we had the Me Too movement, so sexual harassment. We had LGBT issues. We had a changing National Labor Relations Board, a much more employer-friendly board. Right. We had about overtime regulations. We're supposed to be about to come out. The new wellness regulations with the EEOC. Those, how do we do? Were we good psychics?
Well, absolutely nothing happened that we said was not. I'm kidding.
Bad.
The biggest news is that there really isn't a lot of news.
Yeah, well, why is that, do you think?
Well, many of the president's appointments to the boards, have not been confirmed, so they haven't been able to set any agendas, and so a lot of things have been stalled in Washington. In case you didn't hear, there's also a thing called a shutdown.
Yeah, I was wondering. I was going to say that's probably not making things happen much faster with all those people not actually working.
Right. For example, the EEOC is closed for now, and we don't know when they're going to reopen. And when they do reopen, they're not going to have a quorum, so they're not going to be able to set the agenda. The Department of Labor and OSHA and the various other agencies most of them are still open, but they're not doing a whole lot right now.
But let's still go through. We'll talk about some of the things we talked about last year. Start with the Me Too movement.
Right. In the sexual harassment context, in the fiscal year 2018, charges were up 13% in the sexual harassment area. So I think it did have some impact.
Right. Because remember last year you said, we all need to look at our policies and we need to make sure that there's a reporting mechanism for calling out sexual harassment over that top level as opposed to just your mid-manager. Is that still good advice?
Yeah, I think all that advice is still good. It's never a bad idea to look at policies and make sure you've shored them up. And one of the biggest things is make sure your policies in writing have, they're active. They're actually known to the employees.
All right, well, turning to LGBT rights. Last year we were actually talking about the case that was going to go to the Supreme Court, the Colorado Baker case, the Masterpiece Cake Shop, I think it was. He won.
Yes, he did. And for those of you that may not remember, this was a baker who, for religious reasons, refused to bake a cake for a couple. Same-sex couple. Same-sex wedding, and they wanted a cake, and they came in, and he refused. And the Colorado Commission on Human Rights ruled against him. And the court sort of sidestepped the issue of whether or not, for religious reasons, someone could refuse to do that for a same-sex couple. But because they held that the Colorado Commission sort of had a religious bias. And, in their opinions, they kind of showed a religious bias. So they kind of just kicked it back to say, hey, evaluate this the way it's supposed to be.
Yeah, a more neutral standard. It was kind of very narrow. It wasn't exactly saying that you're always fine saying no to bake a cake. But as far as in the employment context, I know we've been waiting on these three big decisions from the Supreme Court for a while now.
The issue is sexual orientation or gender identity. That's not necessarily something that when they passed Title VII, they originally intended to include. That's the argument against it.
Right,
and so you have to amend to include something different. And those that say, no, it's broad enough to include all these different types because of sex includes all of this.
Right.
And so, many companies already have policies prohibiting that type of discrimination.
Of course, yes.
And it's interesting to see what happens.
Moving on to the labor board, something that's actually still open. They called me today, so someone must be there.
Right. The National Labor Relations Board is still active.
That was difficult for employers primarily because they would have a rule that they'd established years ago, something that looked pretty innocuous. You may not scream at customers, you may not argue with your coworkers in front of customers, things that just seemed like civility rules, but the way that the former board was reading them was very expansive and said that could be read conceivably as limiting the employee's ability to exercise their rights under the act. And, we have a lot more logic, I think, and predictability for employers that they can actually use those rules against. So that's good news for them.
That's right. But the board's progress, hasn't always been, it's gone a lot toward the employer side, but there's a lot that they could have done that they still haven't done. For example, they issued a joint employer decision. That was great. It was hailed as, this is great for employers. It changes the previous rules on this and overturns the Obama administration rules. But lo and behold, they had to vacate that order because one of the members the inspector general ruled that he needed to recuse himself.
Yeah.
And so in the interim, the board says, well, we won't issue a ruling. We're going to issue joint regulations.
Yeah. They keep on they keep on expanding the time for comments, under the Administrative Procedure Act. They wanted to do the regulations, so they keep on extending comment time. And then meanwhile, they got that, I think it's the D.C. Circuit decision that just came down. Which they'll certainly challenge, don't you think?
Absolutely.
I think they kind of have to.
Fair labor standards.
I heard those are going to be coming down any day now. Last year, we were checking the news every day to find out what our new threshold was going to be for overtime exemption.
To recap where we were, we've heard some rumors, and that the Trump administration is going to propose a floor of around 30,000, around that, plus some other things, and maybe some alteration of the duties part of the test, but nothing has happened.
I know this is maybe not our most informative show. Speaking of which, what's going on with our wellness regulation?
Well, that's a good question.
Hey,
so glad you asked. There's another regulation that was implemented by the EEOC. A little background on that: under the Americans with Disabilities Act and the Genetic Non-Discrimination Act, there are strict rules regarding what you can ask and confidentiality provisions related to someone's health. They came up with rules that you could implement in the context of a wellness program. And so it was ways in which you could ask information regarding health-related issues for a voluntary wellness program and it not run afoul of the law. And a court held that those regulations were invalid and basically told the EEOC, who issued the regulations, you have until January of this year, 2019, to write new regulations. And lo and behold, January comes. So the EEOC didn't amend or give new regulations. They just pulled the old regulations. So now we have no regulations.
No regulations.
So we think, once again, on the horizon this year, we think the EEOC, when they come back to work, may tackle that, but they may not. I don't know.
Oh, all right, so nothing's going on with the agencies. But, hey, I know there's been a little bit of action at the Supreme Court. Turned on the television at all towards the end of 2018.
There was this little issue, minor, wasn't covered very much in the media.
I know.
A new Supreme Court. We're talking about Judge Kavanaugh, of course. And he was confirmed, I believe, in September, October timeframe. And so now the Supreme Court again has a 5-4 conservative majority. The time will tell how Judge Kavanaugh is going to rule on things.
Right.
And I think his record suggests that he'll be conservative and perhaps be more employer friendly in his rulings. But once they're confirmed, how they rule is, you never know.
What about states? We talked about federal. Is anything happening in states?
There are a lot of things going on. I mean, for example, certain states are becoming more intrusive in what employers must do. It's not enough to prohibit things. They're requiring mandating training, and we provide certain perks to employees, and so on and so forth. There are also many states are legalizing the recreational use of marijuana.
They certainly are.
Which creates a whole unique set of problems.
Yes, we talked about this in the holiday party episode.
Yes, the holiday party episode. Yeah. Limiting what you can ask applicants. So I think states are going to be doing a lot more. And that's why when we talk about all these federal court and federal agency developments, they all need to be tempered with what state you're in. You got to look at the state laws. Always look at the state laws.
Always look at the state laws.
Yes.
You take that away from this. And I think this has been really interesting. Thank you so much for being here and talking about this with us today. All right.
See you next year.
Thank you guys so much for tuning in. Hope to see you next time. Bye.